Okay, well, welcome everybody. Thank you for joining us this evening. If you're near where I am, it's raining. I don't know if it's raining where everybody else is. I'm Erin May Quaid. I use she, her pronouns. I am the Special Projects Advisor at Gender Justice. And tonight I have wonderful panelists joining me, who I'm going to allow them to introduce themselves to talk about the Skrmetti decision that came out from the Supreme Court last week. So Brittany, I'll come to you first. Introduce yourself. You can just give a brief bio.
Yeah, hi, thanks. Brittany Stewart. I'm a senior staff attorney at Gender Justice. And one of the key areas that I've been focusing on is gender-affirming care lawsuits, as I've been lead on our challenge to North Dakota's gender-affirming care ban for minors. So this is very pertinent to the work I'm doing, and I'm happy to be here today to share my thoughts with y'all.
Thanks, Brittany. Dr. Gepferd.
Yeah, good afternoon. I'm Kade Goepferd. I use they, them pronouns. I'm a pediatrician. I've been a pediatrician for about 20 years. I work at Children's Minnesota, where I serve as the chief education officer there. I helped to found our gender health program for transgender and gender diverse youth that we launched in 2019. And I provide care for trans and gender diverse youth and their families.
Awesome. Thank you so much for being here. So we are going to talk about US v. Skrmetti, and this is a case that impacts gender-affirming care for trans youth. We're going to talk a little bit about the background of the case, the opinion of the court, and what this means for access in North Dakota and how it might impact our case in North Dakota, TD v. Wrigley, how it impacts or doesn't impact access in Minnesota, and just what can we glean from this Supreme Court decision. And I think we're just going to start briefly on background. We don't have to go too far into the weeds. But Brittany, I want to come to you first. If you can just talk a little bit about US v. Skrmetti. What is this case? What was before the court? What questions were they supposed to be answering? And where did this case come from?
Yeah, so this case actually started as a challenge to a state law that was passed in Tennessee that specifically banned the prescription of gender-affirming care, such as puberty blockers or hormone therapies, to people who were diagnosed with gender dysphoria and using those treatments to affirm a gender identity that is different from what their sex assigned at birth is. And the law really specifies this all out and is really careful and clear. They didn't just say we're outlawing, all minors having access to puberty blockers or all minors having access to hormone therapies. They very much singled out only children diagnosed with gender dysphoria who are seeking these treatments to affirm their gender identity. And so some families, including 3 minors and their parents, filed a lawsuit against the state of Tennessee in federal court, seeking to have that law struck down as violating their equal protection rights under the 14th Amendment. And then at the trial court level, the court agreed with them that it was likely violating their rights and issued a preliminary injunction. So it said, you know what, we'll put this law on hold while we have further litigation and get this to trial to decide whether this really does violate rights or not. But let's keep the law out, and keep things the way they were before the law was passed in case it is impacting people's fundamental rights. And so then the state of Tennessee appealed that to the Sixth Circuit, where the Sixth Circuit said, no, we actually don't think this likely impacts fundamental rights. And that injunction that was stopping the law from taking effect, we're dissolving that and saying that no longer has to be in place. And so at that point, the United States Department of Justice intervened in the case and sought an appeal to the Supreme Court of the United States over this equal protection clause issue. And so that's how the case got to the court.
And correct me if I'm wrong, but the question that the court was supposed to be answering was the level of scrutiny that the courts were to apply to this case? Am I right? Can you just say one thing about that?
Yeah, so what, like, really the key issue was what level of scrutiny, as you said, was going to be applied here. So typically in equal protection cases, before the Supreme Court or before any federal courts that are interpreting US constitutional law, something that's based on like race or national origin or sex, a law that classifies based on a categorization like that is generally subject to something called heightened review, which means that then it's on the state to show that that law is narrowly tailored to address a really substantial interest. And so there's something real there that needs to be addressed, and that they couldn't be addressed otherwise without having this classification. Um, Whereas if it does not classify based on race or national origin or sex, then it would only need to meet what's called rational basis review, which is basically the state can just have any kind of somewhat rational sounding argument, and the courts have to just kind of take that at face value and be okay with it. And so the real big issue here was, what does this law classify on, and what level of scrutiny should apply?
And I'll, preview for our audience that I think the answers, like the words that I got reading the decision and reading about the decision was like incoherent, incomprehensible, like, gobbledygook. But before we get too far into the decision, I want to come back to you, Dr. Goepferd, because I think it's important for people to understand what gender affirming care is for young people. Can you talk a little bit about how your patients come to you? How do you talk to kids and their families about gender affirming care?
Yeah, absolutely. So, gender affirming care, what is kind of colloquially referred to as gender affirming care, is at its simplest healthcare for transgender and gender diverse young people. And I think it's really important to understand that, like all healthcare, this healthcare in particular has been longstanding. It is evidence-based. It is guideline-driven. We approach healthcare for transgender and gender diverse young people just like we do all other healthcare in pediatric and adolescent medicine. Patients get to us a few different ways. They can self-refer. Parents are often have questions about their young people who are exploring their gender identity and how best to support them or help them or what guidance they may need. So most often parents will self-refer. Sometimes referrals will come from our primary care provider who is unable to answer families' questions or thinks they may need more help or support. And the way that we talk about the care, again, I'm not trying to be overly simplistic, but it is somewhat simple, is very individualized. Every patient and family that comes into us is going to have a potentially slightly different identity, slightly different needs, different family structure and support, different school system that they're operating in. They're going to be at different ages, different developmental stages. So it's very individualized. It's developmentally appropriate. Most often, I often say, if someone could just kind of sit on my shoulder for a day, they would have nothing to worry about when it comes to gender affirming care, and they'd probably get a little bit bored because it's a lot of talking. It's a lot of, asking questions, answering questions, giving information on child development and identity development, helping navigate social situations, family situations, educational situations, and really helping families understand their child or their young person and what they're going through. In some cases, for some patients, it does involve medications, and we talk through those and what the purpose is of those and the risks and benefits. And again, just like any other type of healthcare. And as a pediatrician, I can't provide any healthcare of any kind without parental consent. So parents are always involved in the care. They would provide consent for any type of medication that we may end up using. And so I think, it's not as mystical maybe as as it's made out to be. But I think the thing that is most important to understand is that it is necessary, and it is in many cases, life-changing and life-saving for the young people who seek support through programs like ours.
Yeah, it's I would never want to call somebody's job like boring, but like it's just like really, like healthcare. It's like what you're describing feels like sounding I can't to and like all of my internet is
That's
poor.
okay.
But yeah, it's like all healthcare, it's tailored to the patient and to the
Right.
person.
Yeah. I mean, I
Um,
spent most of my career in primary care talking with families about all kinds of health conditions and, um, giving guidance and advice that was sometimes involved medications and oftentimes did not. And this feels very similar to me.
yeah, that's right. So, Brittany, I'm going to come back to you. The big reason we're here, the Supreme Court, they were supposed to answer the question of what is the level of scrutiny we're going to apply to this. And essentially, and I'm just going to briefly just fill it in, is that essentially the court was like, well, this isn't sex classification because it's age classification, so you can't give care to minors, and then it's medical diagnosis, but it's not about sex. And do I have that right? I mean, that was essentially what the Supreme Court said is it's not sex classification. It's just about your medical diagnosis and your age.
That's exactly right, Aaron. So basically, they could have really had a really narrow ruling here. They could have come out with a ruling that just said the trial court should have used rational basis review. We're sending this back to use that review. Or they could have said the trial court was right to use heightened scrutiny review. But they could have done something really narrow and just said, and so go back and continue the proceedings, and we're not making anything broader than that. Um, but what they did is they did like you said, they said ultimately like, okay, we're going to magically ignore all this stuff that like specifically says you can't get X medication if your sex is Y. We're going to ignore that part of the law and really focus on the age and the diagnosis, and that what this really classifies on as age and diagnosis. And therefore, only rational basis should apply. And applying rational basis, this law meets rational basis review, and we're going to leave these decisions to the states. So they really kind of went a lot further than they needed to, especially at such an early stage in the case where this, again, it was at a preliminary injunction stage. So for non-lawyers, that means that when they filed the lawsuit, they immediately asked for like temporary relief of like, please stop this law while we litigate this because people's rights could be impacted in the meantime. And so oftentimes those are granted while a big issue like this is litigated, and you want to have testimony come in. You want the doctors to come in, you want the families to come in. You want to really hear all of the evidence and from all the people actually impacted to really understand how the law works and how it's interplaying in people's lives, and so that the court can make a decision based on a full breadth of evidence and a record. And so here at such an early stage in the case to just basically apply the review that they said should be applied and say, therefore, states, you're free to regulate in this area and we're going to do nothing. They went further than what was really necessary or called for under these circumstances. Um, and, I'm going to get a little ahead of myself here, but the dissent really picked this apart and pointed out just the absurdity in saying that this law didn't classify based on sex. And really was like, you guys are basically making up logical arguments to fit like the conclusion you're trying to get to rather than actually examining the facts in front of you. And something that stood out to me in the case was the amount of the opinion that was dedicated to getting in the weeds of gender affirming care and what these studies say. and having these Supreme Court justices who aren't medically trained taking, specific quotes from medical studies that mean one thing to medical practitioners, but look like something else to a layperson who doesn't understand that all medical studies say that this is a limited study and we will need more information about this care long term. That's in every study. That's required to be part of medical studies if they want to be published in medical journals. And so when they say they find limitations, they're not saying, therefore, we don't know anything and nobody should get this care. They're just acknowledging it's an evolving science and we're continuing to study more and more and fine tune and get better and better information. So the degree to which these justices seem steeped in this kind of misinformation and pointing to things that clearly are coming to them from their right-wing media ecosystem, and this, lots of citations to the Cass report out of England and just things that weren't really part of the record of the case and that really aren't even relevant to the question at hand. You do not need to settle medical science to make a legal decision on whether a law classifies based on sex or not.
Yeah.
That you can eliminate all those paragraphs from the opinion because they have nothing to do with it.
Yeah. I mean, and it's interesting because the law specifically says that it's to encourage minors to appreciate their sex and to prevent young people from becoming disdainful of their sex. The law specifically says, our goal is to specifically sex classify you from birth and make you stay that way until you're 18.
And require that you meet the stereotypes of that sex for as long as you're a minor.
Yeah. So Dr. Goepferd, I do want to come to you because I wonder if you would be willing to just describe what it's like to be a doctor, be a medical professional, and watch, willful or unwillfully judges and lawyers and people get this wrong all the time, the science and the medicine. What is that like? What would you, if you had been able to testify, if you had been able to give information, what would you have wanted to say to this Supreme Court?
That's a big question. What would I
I know
want
it
to
is,
say to the
right?
Supreme Court? A few things stood out to me, and I'm not a lawyer, but a few things stood out to me as I read through the case and the opinions in the dissent. I think one of the first ones is that Justice Roberts made a comment that there's vigorous scientific debate in this area of medicine. And that really stood out to me because there is not vigorous scientific debate in this area of medicine. There is vigorous political debate around this area of medicine. And in fact, as someone who has been a practitioner of care for kids and particularly care for LGBTQ kids for so long, when we launched our gender health program in 2019, this had not kind of hit the political hot seat. And we weren't vigorously scientifically debating that. The evidence is there. It's very clear. It's been decided. So the science has been decided. And I think as I read through it, it really struck me, and Brittany alluded to this, that it's kind of this political ideology masquerading as science. And I think the thing that worries me most as a pediatrician and as a scientist is that this opinion fits alongside others that are really kind of advancing this anti-science undercurrent that's happening right now. And so it's not scientific the way that this opinion was written or that decisions were made. Just like it's not scientific what's happening with vaccines. I think that there's a lot of kind of anti-science things happening in politics right now, and that just concerns me globally as a pediatrician. I also think that it's another decision that trends in the way of both loss of bodily autonomy for people, particularly minoritized people and trans and gender diverse people, women, that we've seen. And as a pediatrician, really, a pretty strong statement in loss of parental rights and parental autonomy. I'm a parent. I have 3 kids. I expect to consult with a doctor about their medical care decisions, and I expect to be included in those decisions. I don't expect the state of Minnesota or the country to make healthcare decisions for my child based on what they think is best, not what my doctor or what I think is best as a parent. And so I think that's the other thing that I kind of read through this from my doctor and kind of pediatrician point of view. And, I think one of the other things, and I think Brittany, you sort of touched on this, and this is both from my experience of treating trans and gender diverse youth, but also being a part of the queer and trans community as a queer and non-binary person myself, that there's a real dismissive tone about trans identities and the current and historical discrimination that has been experienced by that community, because that was one of the questions. And you take this really small minority population of transgender individuals, and the opinion, as I read it, really claimed that there is no historical discrimination for that group of individuals, and somehow that they would be able to protect themselves at the ballot box, and that it should be up to states kind of what happens to them in their healthcare. And I think that generally our courts should protect people and their healthcare, and protect my patients and their healthcare. I don't want it left up to states and politicians. No offense, Erin, what happens to my patients' healthcare. And I just think that really struck me as well. I mean, I think the court's role is to protect those who are not otherwise protected by society and are discriminated against in society. And this seemed a real clear departure from that.
I can just be honest, the way in which I never want to legislate someone's health care. I have not attended medical school. I'm not treating patients. And that is, I have 2 colleagues that are medical doctors, and even they don't want to legislate people's health care from the legislature. That is legitimately between a doctor and the patient. And, and I also think about too, the world that we're creating where for some people, no matter where you are in the country, you have the same ability to get healthcare, the same ability to get treatment. And then for others, that is not true. That the state that you are in determines the amount of autonomy and the amount of access and the amount of healthcare you actually can receive. And that is a terrifying reality that we are living in. And
I think
Erin, if I could address a couple things Dr. Goepferd said there, because that's a really rich amount of topics there. First off, Dr. Goepferd is absolutely right on this parental rights issue. But one thing I do want to note, the parental rights issue was not before the Supreme Court in this case. So it is an issue that was raised in the litigation in the underlying case that could still be litigated and could still make its way up to the court. So I do want to be clear about that, because this case was really just narrowly focused on this equal protection issue. There are some other rights and other claims that the court didn't touch here. So while this impacts those rights because of the decision they made, they didn't actually talk about those rights and whether that might be a different claim for which they may come out with a different decision. So I just wanted to clarify that. And then also on the bodily autonomy issue, this case is an extension of Dobbs. The Dobbs decision that undermined the right to abortion and reproductive care reared its ugly head here. It was part of the precedent cited here because the Dobbs case stands for the proposition that merely because the regulation of care might affect one sex and not the other doesn't mean that it is a sex discriminatory policy in some way. So this is an extension of that, and it's a part of the reason why one of our co-counsel in the case in North Dakota is the Lawyering Project. They do a lot of focus on reproductive health care cases. And so a lot of the reproductive rights organizations do understand that the right to reproductive care and the right to gender affirming care go hand in hand and are all part of the same legal rights infrastructure that we're all fighting for together.
Yeah. Dr. Goepferd, did you want to add something? I'm sorry, before I move to the next question. Go ahead.
No, I don't think so. I think I forgot what I was going to add, so it probably was not that important, or it'll come back to me.
Well, I want to talk about what the opinion means, and I'm going to start with our case in North Dakota, TD versus Wrigley. Brittany, does this change anything about our case in North Dakota? Does it mean it's not going forward, or it still is? Like, tell us what this means for access in North Dakota and what it means for our case in North Dakota.
Well, because we have a great legal team that was very forward thinking and could read the tea leaves of where this Supreme Court was likely headed on these issues, the case in North Dakota, TD v. Wrigley, was filed under state law. So we cited the North Dakota state constitution and made claims under the state constitution in state court. So while this opinion might be instructive to our judge on how he might look at our equal protection claim, the claim that I think we were finding the most traction with in court was actually our fundamental right to personal autonomy claim, which is under Article 1, Section 1 of North Dakota's state constitution, and in which their Supreme Court at the state level just in the last year has said that right includes the fundamental right to choose your health care options as it related to abortion. And so in something as controversial as abortion in a red state like North Dakota, the fact that the majority of their court said, you know what, this is a fundamental right under our state constitution to access life and health saving care that falls under that right to personal autonomy. We're making that exact same argument here for our clients who are seeking care to live authentically and healthily and as themselves without the need for self-harm or potentially losing their life either to their own hands or to the hands of people who hate them. These are folks who have a right to get the care to help them live that authentic life. So that claim isn't affected whatsoever by this case and will go forward all the way to the North Dakota Supreme Court, regardless of this case.
That is a breath of relief. How about Minnesota? Is anything affected here or impacted here?
So, because Aaron, you and your colleagues in the legislature and the governor were able to pass bills to make sure this care is protected in Minnesota. As of now, this case does not impact Minnesota because all the court said is the states can ban this care. They did not say this care is banned nationally or, not protected at all. Just that if a state wants to do it, as long as they can find some way to classify it in a way that this court will say isn't classified on sex, even if it clearly is, then they said the state can do it. So in those states that have passed bans or where bans are likely to pass, it does impact those states, but right now Minnesota is safe.
That's so good to hear. And yeah, I think that if a state who said this law is to encourage minors to appreciate their sex, if that isn't sex discrimination, I don't know what this court was doing. Sex discrimination, unfortunately. Dr. Goepferd, I want to come to you. So care is protected in Minnesota through state law. What is the landscape right now for treating your patients, for providing care? How are they feeling when they're coming to you?
We are so fortunate to be in Minnesota and to have the laws in place that we have, and that still does not make people feel safe. My patients and their parents are very worried about their future ability to access care in Minnesota, even though we have the trans refuge bill in place. And I've certainly had patients who've preemptively left the country because they're worried about their rights being infringed upon here. And I think, the other thing in terms of myself and my colleagues is that this decision by the Supreme Court, we were kind of all hoping this would go away. We know the science, we know the healthcare, we stand firmly in that. And we're used to sort of science and reasoning and showing the evidence kind of playing out in the way that we expect. And in this case, and with this Supreme Court decision, I think that the states that have bans in place are going to continue to have those bans in place, and they will be harder to challenge, which means that we will continue to have more and more families both traveling here from care. They fly here, they drive here, they're sent to stay here with family members so that they can get health care, and relocating to Minnesota. And that's been a trend that we've seen since the passage of the trans refuge bill. And I think that we will only continue to see more of that. And I've tried to sort of explain this to my colleagues because they'll say things to me like, well, but it's fine here in Minnesota because we have a state law. So kids here in Minnesota are fine. And I just want to read something I wrote down. This was in Justice Sotomayor's dissent. She said, this decision abandons transgender children and their families to political whims. And I feel like that is exactly what this decision does. And that is exactly what every family is feeling right now. And it doesn't matter if they live in Minnesota, and it doesn't matter if they live in another state that has a refuge law or doesn't have a refuge law. The message was that our transgender young people are vulnerable to politicians' views on who they should be and how they should be and how they should act and how they can show up in schools and in sports and in healthcare settings. And that is a really terrifying place to be in. So even though I'm so grateful that we can continue to provide, wonderful, high quality healthcare to patients here in Minnesota, I would be misspeaking if I said that, everything's fine and everyone feels great.
Yeah. And I think that's right. I don't want folks to feel alone if they're feeling that way. It's, it is a modicum of comfort to know that care is not impacted here, but that doesn't change the landscape under which people are living in the country that we're living in. I posted in my work Slack yesterday, I posted a clip from The Love Boat in 1982, where one of the main characters, his former roommate comes on the ship and he recognizes her. Oh, maybe she's related to his former roommate. Maybe it's his sister, and it's actually his former roommate. And she has transitioned. And it's this beautiful 1982 Love Boat episode where he is like, it must have taken so much thoughtfulness and internal, reckoning to like decide who she is. And she's like, come here, and and like he's defending her beautifully, might I add. It holds up very well. And it's like, okay, well, so this episode of The Love Boat was in 1982. Like, this is not a new issue, but it's a new political issue. And it's so disheartening to know that at times throughout our history in this country, the Supreme Court has found its way to decisions that, while not politically popular, legally just and right. And in this case, it feels like the court found the outcome they wanted and then worked their way backwards with really like kind of ridiculous legal reasoning in order to get there. And it's really unfortunate. And I think it's why, Sotomayor, usually when justices write their dissents, they say, respectfully, I dissent. And Justice Sotomayor signed her dissent in sadness, I dissent. Because it really was a shameful day.
Yeah, Aaron, before we leave that, I think you touched on something there, and this goes back again too, though, to when this case came up, because it was at that preliminary injunction stage, and I heard Dr. Goepferd mention this again too, this history thing that came up. Well, that history wasn't part of the case that came up. And so there wasn't evidence of historians putting stuff in the trial record to be able to show the justices that no, like there is historic discrimination against folks like this. Or, historically, people felt all kinds of different ways. Whereas, so in North Dakota, in our TDV Wrigley case, we did go to trial. So we had a full trial that went on for 6 full days in the courtroom. And two of the witnesses that we put forward were history experts. 'Cause we wanted to talk about the history of trans people in America to show that when the North Dakota Constitution was passed, the people who passed that Constitution meant for it to apply to everyone, and they knew that trans people existed, and they did not exclude them from those rights. So, we actually took the time to show the court why these rights are supposed to apply to everyone, and why, if they weren't meant to apply to everyone, they could have said something then, because trans people did exist then. In fact, they tended to end up in higher numbers on the frontier in places like North Dakota, because they were oftentimes leaving their more cloistered towns back east, looking for a fresh start where they could take on a new name and a new identity without people asking a lot of questions. And on the frontier, as long as you worked hard and showed up and could like contribute to the community that was trying to build something out of nothing, people were a little more willing to look the other way because it was just all hands on deck. Hey, if you're here trying to make a fresh start, we'll just kind of, live and let live and ignore whatever past life you may have had, and welcome to the community. Now, there were people who didn't like that, and there were people who had negative feelings, and some of the headlines that got passed around in newspapers in that time period were very sensational. But it was clear that people knew these folks exist, they're parts of our communities, and nobody was going out of their way trying to say they don't have rights.
I mean, what a good little like chunk of history for Pride Month. I really like that. We are starting to get questions in the Q&A, so I'm going to start with you, Dr. Goepferd. Has Minnesota seen any indicators that, and I think you spoke a little bit about people who are traveling, but are you seeing more individuals from North Dakota and South Dakota and neighboring states? And do you think that there's going to be an increase from non-border states? I know sometimes it's not like the closest state, but the most direct flight.
Yeah.
Talk a little bit about that. Yeah.
Yeah, I mean, we have progressively seen more and more. I think early on, as bans around Minnesota began to go into effect, we had patients from North Dakota, South Dakota, Iowa coming here. The longer that things have stayed status quo, we're seeing patients from farther away: Kansas, Missouri, Texas, Tennessee, Florida. So yes, we are seeing patients from kind of all over. And my suspicion is that states that do have refuge laws in place or shield laws in place will continue to see more out-of-state patients seeking care there, because they're perceived to probably be more safe and stable in terms of that care not changing and then them having to reestablish in a different state. And we've also seen a trend of people moving here from those states as well, which, I am not a native Minnesotan, but I have been here 25 years, and I love the state of Minnesota, and I really love what we stand for in terms of people belonging here. But I have a lot of sympathy for people who have moved here when that was not their plan. And though I don't plan to live in Texas anytime soon, the people who moved here from Texas had planned to live in Texas. They have family there. They may have had businesses there, history there, community there. They weren't planning to move to Minnesota, and we try to welcome them with open arms. But it is really sad to see families being so displaced from their communities and their support systems. And I'm glad that we can welcome them here, but I do think that trend will continue to increase.
Yeah, and we can't ignore, I mean, I'm a lifelong Minnesotan. I live in the same city I was born and raised in. And I can't imagine moving, having to leave behind, my family, my home that I love, like knowing the way to the grocery store, knowing where the
Right.
Puppet cart comes during the summer. I know which parks they're at.
Mhm.
But we're also in a notoriously difficult state to like make friends in. I want to just acknowledge that.
Yeah.
But also, when you plan to move, like there is something that literally happens with your body, even if you're nervous about it or scared about it, but it's fleeing, right? You become, you migrate somewhere else to escape like what is essentially like terror being wrought upon your family and upon you. And like all the times that we've had to do this in this country are not good times, right? When we've forced people to move because of different state laws, are not times we look back on and say, gee, how great things were. And it's
Right.
just, and not
And I think
everybody,
we have to remember, like, these are kids too. I
yeah,
mean, the thing that I hold when I see these kids in clinic is that these young people they're holding this for their families. Like they know that it's because of their identities that their family had to move. And the family's not blaming them. And they're often very, we would do anything for our kid and we love them. But the burden on a young person, whether they're 8 or, 17 or however old they are, knowing that their family left their whole life because of their identity and to help protect them. What an act of love, but what a burden for that young person to carry. And Erin, you're right. I see these families in clinic, and they'll say to me, well, what's Cub? Like, is that a grocery store? I mean, because if you haven't traveled around the United States, like the grocery stores are different. Like people
yeah.
don't. I mean,
I
it's
don't
a
know what a
whole
Wawa is.
yeah, it's a whole different thing, and it is not insignificant what's
Yeah.
happening.
And often when you move to, right, if you move for a job, for example, there's some culturalizing that happens through your job, at least, where they know
Mhm.
you're new and they know, things that you might want or need. And if you're just, I mean, we've seen even in my own community, we have families that are broken up. So like one parent moves with one
Mhm.
child here and the other parent stays with the other child or children in their home state because it's safer for the one child here, but they can take 3 or 4 kids out of school or they couldn't give up the one job. I mean, it is just, it's horrifying. Um,
That
the,
reminds me, if I might, the thing I was going to say earlier that I forgot and then I remembered. Um, when Brittany was talking earlier, she referenced that this decision had referenced things like the Cass report out of the UK, and I often hear people talk about, other countries and their different approaches to care. And I think that one thing that often gets lost in that conversation is the concept of nationalized healthcare
mm,
versus the type of healthcare we have here in the United States. And it's one thing for a country that has nationalized healthcare to say, okay, this is how we are going to approach this type of healthcare in our country. And we're going to centralize it and we're going to enroll kids in trials and we're going to do it that way. That is so incredibly different from the model of healthcare that we have in the United States, where whole states can literally ban entire types of healthcare from people, leaving them to have to travel all over the country to get it. And that's not what's happening in any of these countries over in Europe. They are making changes around their national healthcare systems and plans. They're not banning it in particular parts of the country and making people I mean, it's just so different. So it's like comparing apples to oranges, and I feel like that often gets lost. So I
mhm,
just wanted to sort of, from my medical perspective, bring that up, that when these people are traveling for care, when these families travel, their healthcare insurance doesn't cross state lines often. Or if it does, they have really high deductibles or they have to
yeah.
pay out of pocket for it. And we don't have the kind of healthcare here that allows people to move freely around the country to get their healthcare. So I think that's important to remember.
Yeah, I'm
I'll
glad you
I'll
bring
stop.
that up. No,
Okay.
I'm glad you bring that up. It was, when we had this conversation at the legislature about, healthcare for immigrants, and it was like, nobody's leaving their country that has national healthcare to come to this country for our shitty healthcare system. Just that's not happening. Um,
I'd kind of like to elaborate a little bit on that too. When you're talking about accessing this care, we have, our clients in North Dakota have had to come to Minnesota to access this care. And something to expand on that Dr. Goepferd was getting at previously was, yeah, this care is protected, but there's still only like a finite number of people practicing in this area. having to add all these extra patients, it's caused increased wait times for people to get appointments. It's caused like the folks who have to travel, like the doctors that see them in Minnesota don't want to even call them with like updates about their care if they're in North Dakota when they make the call. Like they have to wait till they get back to their Minnesota office before they can even like call them back with an update. So if they happen to be practicing in Bismarck that day, they got to wait to call that particular patient back, 2 days later when they're back in the Moorhead office. And it's like, these are real impacts that are happening. Like, so even though technically you're getting it here, it's impacting the people coming from other states. It's also impacting the patients here because now there's more people they're competing for appointment times with. So something that Minnesota will need to grapple with is how do we expand the number of providers to be able to take on the additional people seeking refuge here because of the Supreme Court allowing this state by state mess.
Yeah. Oof. I'm gonna go to another question that we have. We currently have access to care in Minnesota. How concerned as parents should we be about potential national bans on care or threats to health systems who provide healthcare to children?
I mean, we should be concerned. The Republicans who are obsessed with this issue nationally, um, you know, they've got the presidency, they've got the House, and they've got the Senate. So they could pass something. I do expect, I think the Democrats and the Democratic aligned senators would likely do what they could to try to filibuster a national ban. But that's not a guarantee. And so it would be definitely a big fight. Luckily, that fight hasn't had to happen yet, but that is something we could see, and that based on the way the court analyzed these laws at a state level, there's reason to believe they would apply a very similar analysis to a national ban. And so then it would matter on how you challenge that ban. So we would want to challenge it on other grounds beyond this equal protection challenge. So that's why it's important to remember that this case was just limited to that equal protection issue. So if a national ban were to come into place, litigators would just have to litigate about different issues. So we'd go to like the fundamental parental rights to direct care for their kids, and other personal autonomy rights that we might be able to find and get a different analysis.
I will also just note that in the reconciliation bill that passed through the House and is being considered by the Senate federally, does include prohibiting gender-affirming care from being accessed on Medicaid. And so, Minnesota is a state that covers gender-affirming care through Minnesota Care. Although it was a court decision that initially got it there. So I'm not really sure how that all balances out, but it's not a national ban. But it is, going after a significant portion of people who access gender-affirming care, both adults and children. And so I just want to be, candid about that is something that's percolating. Dr. Goepferd, did you have something to add?
No, I mean, I'm not in the business of political analysis, so I will let both of you sort of, look into the future of what might happen. One thing, I am in the business of working in a hospital, and I know that one question is whether the care is banned or not banned, or deemed to be, legal or illegal or constitutionally protected or not. Another issue is whether there are clinics and providers to provide that care. And so, things like revoking Medicaid reimbursement for care, or punishing hospitals with funding decisions, or trying to punish providers, which we've certainly seen come out of the Department of Justice and some of the things that they have said. So I think, when I'm talking with families, my radar is less on a national healthcare ban and more on how difficult and painful, and using what levers and tools can those who are seeking to prevent trans kids from getting the healthcare they need, like what are they going to use and how will that impact our ability to provide that healthcare?
And an analogy that folks can use in their head is just think about how abortion care has been treated, right? So it is mainstream healthcare. It can be provided by a primary care provider anywhere. Your like primary care clinic, it can be in a hospital, it can be a standalone clinic. But because of the politicization of the issue, it was pushed out of primary care into special clinics with special providers in special places with special laws. And it made it a lot easier then to target those places, those providers for harassment, those patients for harassment. And, abortion at its longest is like a 2-day process, maybe 3. Gender affirming care is ongoing. And so, that the prospect of having to encounter what abortion patients encounter, but on a regular basis. I mean, that's part of creating this culture of fear and terror. Trap laws, so targeted restrictions on abortion providers are another way. Like there's lots of ways to restrict access to care to make it essentially banned without actually having to, maybe is a better way of saying that. That is what happened largely in the South before they overturned Roe v. Wade, is that care was essentially unprovidable for abortion because of the way that they had already regulated it legally, that the Supreme Court allowed. There's a question in here about insurance companies questioning medications commonly used in hormone replacement therapy and the possibility that insurance companies will be able to transfer that here to Minnesota.
Do you want to, I mean, we do have legislation, correct me if I'm wrong, that protects coverage here in the state of Minnesota. I think, I do think as a healthcare provider, what we have seen is that when Medicare and Medicaid tends to drop coverage for things, private insurance companies tend to follow suit. There is legislation in Minnesota that should prevent that.
Yeah.
At this stage, I think that is a very good reminder that every election and every voting cycle matters. Like who our state legislators and our state senators and who we have here in Minnesota, our governor, our lieutenant governor, absolutely matters here, because that is a law that we have now. And we need to keep that a law so that insurance rules don't change here in Minnesota. Because yeah, I think that is something that can happen with insurers, is that they will change their policies, but at least for those folks living here in Minnesota, that should be protected.
Mm-hmm.
I can tell you on the legal team, we have had a couple reports come in of people maybe running into some insurance hiccups around this care. It's unclear at this point that was because of anything related to gender affirming care, or if it was just typical
Insurance
mishaps that happen to anyone who gets medical care. We all love dealing with our private insurance companies. They're the best. No. So there's bureaucratic issues that pop up. So it could start to happen more. As of now, I can't really substantiate that there's been anything in Minnesota yet.
Brittany, one thing I'll maybe add to that point, because you brought up a very good point. There's something called prior authorization in medicine, and it is something that is the bane of our existence in medical care, where essentially, if we are recommending a treatment or a therapy for a patient, an insurance company may ask us to prove through various submission of documents or information why that is an appropriate therapy for that patient. And so this happens for us often in the provision of medications as part of gender affirming care and other areas of medicine as well. And we have started to see a trend of more requirements for certain pieces of information or laboratory studies or things that are essentially justifying our care decisions as part of that prior authorization. So we have sort of seen a trend toward kind of more information or more stipulations needed before an insurance company. So they're covering it, but they're they're wanting more information, which often then leads to sort of a delay or more barriers to care for patients.
One of the banes of my existence and one of my goals as a lawmaker, if I may, is to get rid of prior authorizations. I hate them. I've always hated them, but I have a daughter who has asthma. She's had asthma since she was like 9 months old. She has an inhaler. They discontinued the inhaler that she's had, so she needed a new one. And the like weekend that I was fighting with the insurance company to give my 1-year-old an inhaler for the asthma that she has, they were like, well, why, like, are you sure she needs it? I'm like, how do you know? Are you practicing medicine? No, you're not. Like, it was infuriating. And that's just for asthma. So like, I can't imagine what it's like for, you know, for anything else. Insurance companies are we'll do a whole separate conversation on those one day. I'm going to answer 2 questions very quickly. Do we anticipate people in Minnesota will try to overturn our protections for trans youth? That is going to heavily depend on who is in charge. The current makeup of the Minnesota legislature and the governor, no. That could change, right? It's that could change. So right now, no. Will a cut to federal funding have a similar result as a ban for Minnesota for those on state funded insurance, or does Minnesota have funding to cover this loss? To the best of my knowledge, I don't know. And the reason why is because the required coverage under Minnesota Care for gender affirming care before the law came from a lawsuit. And the lawsuit essentially said what the Supreme Court decision should have said is that you cannot deny people medical care based on the reason they need it, like based on the fact that they're transgender, because hormone replacement therapy you can get if you're cisgender under Minnesota Care, but they were denying people who are transgender under it. And so that was the legal decision. And so I don't know what happens if the federal government changes their reimbursement model. Like, I believe that that court decision still remains in place. And so I don't even know if it's a question of, do we have the money? I don't know if we have I don't know if we are allowed to decide not to. And so I have to look into that and get back. Brittany, do you know off the top of your head? No. Okay.
That's a difficult question that will take a lot of additional exploration.
Jess Braverman would know, and maybe we'll put it into a newsletter update soon. Brittany, I'm going to come to you, and the question is, acknowledging that you don't have a crystal ball, but if the North Dakota ban is overturned, what approaches might North Dakota legislatures take to limit or ban gender affirming care under SCOTUS's ruling? And don't give them too many good ideas.
Yeah, I mean, you know, part of our argument in our case is that the law they passed in North Dakota was not narrowly tailored enough. And that in fact, even that CAS study that even the state of North Dakota kept trying to point to, and even some of their own experts that they had testify, agreed that there are at least some minor children who are suffering gender dysphoria for whom this care is necessary. They might have a debate as to like how many it should be necessary for, but even some of their own quote unquote experts had to agree that there are at least some for whom it is necessary. So the argument we're making is that the law has to be narrowly tailored in such a way that the folks who do need the care have to be allowed to access it. So I think what we'll see is, if we get the opinion, I hope we do, then what we would likely see is the legislature have to actually dig in more deeply and not just go off of a bunch of misinformation and really try to hone into, you know, how they allow the diagnosis to happen. And they'll get really highly specifically regulated and try to narrow it to such a degree that it applies to almost nobody. So that would be my guess as to where they would go if they want to keep arguing in this area. I mean, we could also, maybe we just beat them so bad that they decide to go away. But they won't. So
I just want to say that if the legislature had written into law the process through which one has an appendectomy and then it was in law, then it could never change. And I guarantee nobody wants an appendectomy today like somebody had in 1990. Promise. That is just it's such a absurd way to legislate. Well, I'm
I
gonna
mean, real
oh,
real quick, I just because I know we're at the end, but this is really funny, because it does show the absurdity of these legislators. In just the last couple of years, the same North Dakota legislature that outlawed gender affirming care and used as one of its reasons to outlaw it was because the medications were being used off label, actually passed another law that required that North Dakota's version of Medicaid cover all off-label uses. So on the one hand, they know that you're supposed to cover off-label use. On the other hand, off-label use is clearly an example that this shouldn't even be happening.
well, I want to close us to just have any final words. Dr. Goepferd, I'll start with you. Folks, what do you want to leave them with?
Yeah, I mean, I think when I was kind of reflecting on doing this panel on the Supreme Court decision, one of the things that really struck me is that, I believe this is an infringement on patient rights and parent rights, but it's also an infringement on my right and ability to practice as a pediatrician. And, when I became a physician and a pediatrician, I did so because I really want to help kids thrive and reach their optimal outcomes. And I took an oath not to provide or protect my patients from harm and really to provide them the best care possible. And when when or if I am not able to do that because a court is limiting my ability to do that, um, it really causes a lot of moral distress and an inability for me to provide care to patients who need it. And so I think I just want to maybe leave with that I think every young person and every parent and every family deserves to access the healthcare that they need to thrive and to be the best version of themselves. And for any, I don't doubt there are young people on this call, but for any parents of young people on this call, transgender and gender diverse young people are absolutely a gift. They are a gift to me and my practice and my partners, and they're a gift to this world. And for them to be made to feel like they aren't, or that there's something wrong, or that they don't deserve protection, feels very sad to me. So hopefully on this, what is Pride Month, we can remind all of the trans and gender diverse young people in our lives how amazing they are, and celebrate them because they deserve it.
Brittany, final thoughts?
Yeah, I just want to say, not everything we do is always going to win. There are going to be setbacks along the way, but that doesn't mean we're going to give up. It doesn't mean we're going to quit fighting or that we were even wrong. It just means we've got to keep relooking at everything. One of the things we did at Gender Justice, already seeing this happening before it even happened, was to like, hey, what about state courts? There's a lot of rights that people have that are in state constitutions that aren't as spelled out in the federal constitution. And so, there are ways we can fight these things at the state level and at other ways that we're going to keep the fight up and we will win eventually. So just know that and don't give up hope just because things are a little bit dark right now.
Yeah, I think I'll just leave with some words from Justice Sotomayor, Justice Kagan, and Justice Ketanji Brown Jackson in their dissent. They wrote, the court's willingness to do here to obfuscate a sex classification that is plain on the face of the statute, to avoid the mere possibility that a different court could strike down SB 1, does irrevocable damage to the Equal Protection Clause and invites legislatures to engage in discrimination by hiding blatant sex classifications in plain sight. It also authorizes, without second thought, untold harm to trans children and their parents and families who love them. And, you know, it's so important that we have human beings who see other people as human beings on the court. And Chase Strangio, who was the first trans person to argue in front of the Supreme Court, who argued in this case, said that this is a painful setback, but it does not mean that transgender people and our allies are left with no options to defend our freedom, our healthcare, and our lives. And that is what we will continue doing here at Gender Justice. I'll invite Lisa to just put any links that we had related to the closing of this event, you know, for going forward. It's Pride Month. We have some trainings coming up. So our trans equity training, please feel free to sign up there. We also have a trans inclusion in sports letter that we are having folks sign. If you are an athlete, a parent, a kid, somebody who cares about sports, an ally, please sign on to that. And just show our support for trans inclusion in sports. I want to thank everyone so much for giving us, you know, like an hour-ish of your time tonight, and for coming together in community this Pride Month. We are going to continue to be with each other, continue to fight for our freedom and our healthcare and our lives. And I want to thank Brittany and Dr. Goepferd for being on the front lines of that fight. Thanks so much for joining us. We'll see you next time.
Thanks.